Your Honour, my name is Byrne, initials BM, and I appear on behalf of the accused in this matter. Your Honour, if it pleases the court, I would like to make an application on behalf of Simon to have the record of interview excluded on the grounds that it was obtained improperly and in contravention of law. We apply for this ruling under Section 590 AA of the Criminal Code Act. From the facts, there are a number of issues that may relate to the public policy exclusionary discretion, also known as the Bunning discretion, in the case of Bunning and Cross, and the fairness exclusionary discretion, known as the Christie discretion, from the case of Crown and Christie. Police officers have a responsibility under the Police Powers and Responsibilities Act, and from the facts, there may appear to be a few breaches. So, the first potential breach of the PPRA stems from the length of time that Simon was initially in detention for investigating and questioning. Section 403, subsection 2 of the PPRA states that the person being detained under this part cannot be detained for any more than 8 hours, unless the detention period is, of course, extended. However, there is nothing to suggest that the police officers sought for an extension. Simon was formally charged at 7:05 p.m. This meant that over 9 hours had elapsed since he was first arrested for an indictable offence in the nearby Burley's house. This is therefore in contravention of Section 403, subsection 2 of the PPRA. The second potential breach stems from Sections 420 and 421 of the PPRA, which relates to the way in which Simon was treated, both as an Aboriginal and Torres Strait Islander and as a child. As detectives would have suspected that Simon is an Aboriginal and Torres Strait Islander, this section would apply under Section 420, subsection 1B of the PPRA. Now, while the police officers had told Simon that the local Aboriginal and Torres Strait Islander legal aid service would be notified by phone that he was in custody for the offence, no record of the call was made. The police officers should have at the very least attempted to contact a member of the local Aboriginal and Torres Strait Islander legal service pursuant to Section 420, subsection 2B of the PPRA, as Simon had made it clear to the officers that he did not know of any lawyers, and greater care should have been taken as a child on top of this. Furthermore, as the interview was conducted by detectives without allowing Simon to speak to a support person or with the support person present during the interview, this contravenes Section 420, subsection 4 of the PPRA. So the Bunning exclusionary discretion essentially means that those who enforce the law must also abide by the law. The public policy exclusion is a discretion made on the basis of 5 factors. While the conduct of the police officers may not amount to a deliberate breach of the law, the actions were negligent and showed very little care towards my client. Leaving Simon in the back of the police car for 3 hours, only to contact Aboriginal and Torres Strait Islander legal service and detaining my client for more than 8 hours should all amount to a deliberate breach. Having said that, you may take a different view. So if you thought that the conduct of the police officers was a genuine mistake, the cogency of the record of interview will mean it will be unlikely that it is excluded, as it is critical to the Crown's case. The manner in which the record of interview was conducted, i.e. not extending the detention period, seems to suggest that the police was cutting corners. The conduct of the police officers indicates that they were acting out of convenience rather than necessity. As this is a trial for murder, it is understandable that the sheer gravity of the charge would mean the record of interview would likely not be excluded. The purpose of the PPRA, pursuant to Section 5, subsection E, is to ensure fairness to and to protect the rights of persons against whom police officers exercise such powers under this Act. This indicates that the statute is meant to prevent these sorts of acts from happening. The Noongar rules, from the case of Crown and Ananga, sets out guidelines for a manner in which Aboriginal and Torres Strait Islanders should be interviewed by police. While the guidelines are not necessarily binding as a matter of law, the case of Crown and Wilson suggests that it is relevant to consider a breach of the Ununda Rule in determining whether it is fair to admit an interrogation of an Aboriginal or Torres Strait Islander into evidence. If this piece of evidence was admitted, it would be gravely prejudicial towards my client. The probative value of the record of evidence would not outweigh the gravely prejudicial manner in which it would be presented to the jury. So I believe that due to these circumstances, the events prior to the confession being recorded and it being critical to the Crown's case, the jury will likely give this evidence more weight than it actually deserves. So therefore, Your Honour, I seek for the record of interview of my client to be excluded as under Section 130 of the Evidence Act on the grounds that it was obtained improperly and in contravention of law.